for now, I want to turn to a really amazing panel of leaders to talk about their own experiences with crisis lawyering and with crises in general, and particularly to pick up on some of the themes that both Eric and Ray raised about dealing in uncertainty and rapidly moving events, and most of all, the need for cross-disciplinary collaboration to solve what are inherently cross-disciplinary problems. I'm going to introduce our amazing panelists one by one, and as I introduce them, I invite them to please turn on their cameras, and then we'll get started. But just to remind you, please do put your questions in the Q&A. We actually got some terrific questions, which we'll try to get to in the course of this and the next panel already for Ray and Eric in their great discussion with Dana. So let me start with Tom Balint. Tom is currently the Director of Emergency Management at the U.S. Department of Interior, where undoubtedly he's dealing with these issues every day. But this isn't Tom's first rodeo. Before that, he was at FEMA as an Associate Chief Counsel for Resilience and served as a Deputy Assistant Administrator for Grants and Senior Counselor to the Secretary of Homeland Security. And before that, he was the Deputy Attorney General for Homeland Security and Emergency Management for the state of New Jersey. And in these various positions, he's dealt with everything from the COVID crisis currently to the Deepwater Horizon oil spill to the Boston Marathon bombings to the 2017 hurricane season. And if that weren't enough, he's also has been for many years a volunteer firefighter where he serves on the front line of crises. Next, we have Beatrice Lindstrom. I'm so thrilled that Bea is able to join us today. She is a lecturer on law and clinical instructor at the International Human Rights Clinic right here at Harvard Law School. And I've had the chance to have her appear in my class, and I know just what a spectacular thinker and speaker she is. Her work focuses on access to remedies for human rights violations and accountability, with a particular emphasis in Haiti. And as Ray already just said, Haiti has been such a country which has faced so many crises and so many tragic situations. And she's going to talk about one in particular that followed not the most recent earthquake, but the earthquake in 2010 that devastated the country. And what devastated it even more was an outbreak of cholera that unfortunately turned out to have been caused in part, or maybe solely, by the United Nations. And she'll talk a little bit about what that raised for her as a human rights lawyer working in Haiti. Next, we are very, very fortunate to have my dear friend Ralph Martin join us. Ralph is currently the Senior Vice President and General Counsel of Northeastern University. And at Northeastern, he directs everything from kind of city and community affairs to risk management, to labor relations, to legal affairs and public safety, which, as you can imagine, has been really at a critical juncture in the last 18 months to 2 years. But again, this is not Ralph's first rodeo either, because prior to that, he was not only a senior partner, in fact, the Boston managing partner at a major law firm, Big & McCutcheon. But before that, he was the Suffolk County District Attorney for 10 years, where he dealt with crisis situations pretty much on a daily basis. And last, but certainly not least, I want to welcome to the stage Jacob Silverman. Jake is the CEO and member of the board of Kroll Inc., which many of you know is really one of the world's premier investigations and risk consulting firms, which now really has broadened its remit in recent years to look at all kinds of services around digital products related to valuation, governance, risk, and transparency. Again, a place where he deals with crises pretty much on a daily basis. I hope you can see why I'm so excited to begin this conversation. And I'm going to begin, Ralph, with you. And it's partly personal because, as Ralph knows, my son started Northeastern in the fall of 2020, right in the midst, of course, of the COVID outbreak. But Northeastern, unlike many other schools, managed to not only stay open, but to have students on campus, and did a number of really innovative and significant things to respond to the COVID crisis, to keep the university up and running. And I wonder, Ralph, if you might just kind of begin by telling us a little bit about that process, and in particular, how you, in your role as Senior Vice President and General Counsel, collaborated with university administrators, public health people, all the other people, labor relations, that were required for that amazing feat to have taken place.
Thanks, David, and thanks for having me as a participant today. When I think about where we started in facing up to the challenge of the pandemic, I was researching some of the timeline in reverse, and in February of 2020, we were fortunate. We had literally a world-renowned expert as a faculty member here, who's known for his research in network theory, particularly as it applies to the spread of disease. And we began to get briefings from him in February, and he told us that their early indicators were far too conservative, and that the disease's spread and mortality within the US would be much more ominous than others were predicting at the time. So we knew we had to take action. And here the term "we" is not just a third-person reference. The speakers earlier talked about working within the construct of a team. And so the senior leadership team here at Northeastern was very accustomed to working as a team. And all along, I felt that, my participation as the general counsel for the university, and indeed our legal team, was never one-dimensional. So we already had that muscle developed, but I would say this was certainly the most dire challenge we had ever faced at the university. I can only remember one other time professionally where I faced something as dire, but certainly not as long as the pandemic posed as a challenge. So I think to be an effective lawyer, counselor, and partner within the team setting as a lawyer, particularly in the midst of a crisis, means you have to use multiple skills and sensibilities. And so maybe the first point I would make is, and it sounds pretty mundane, is don't just be a lawyer. Be a strategist, understand nuance, and have a view to how multiple constituents, including regulators and the outside world, will view your actions. You're not just making legal decisions, you're making judgment and long-range and far-reaching decisions that will be scrutinized from many different angles. So you have to incorporate those views into the actions that your team is taking and that you're recommending. There are a couple other points, and maybe these seem mundane too, but sometimes in the face of a crisis, people freeze, institutions freeze. And in this case, we all knew that inaction was not an option. But taking action, particularly when there was a great deal of uncertainty about government guidance, government authorization, as well as the law, taking action required assuming a certain amount of risk. And I would say lawyers in general can be risk averse. But if you're trying to guide an enterprise through this very difficult decision tree environment, if we do this, what's the repercussion? If we do that, what's the repercussion? Where the repercussions themselves are not always clear or foreseeable, you cannot freeze, and you do have to take some degree of risk. I mentioned the information that we received from Professor Vespignani. Here, this may fall into one of the strong suits of lawyers. Data and evidence are your allies. We had a lot of data. We had a lot of evidence that guided our decision-making in the first instance, which was to close down, for the most part, the place-based learning for the university. And it's important to use data and evidence wherever you can. I would say another point is you have to identify your constituencies. It's very easy to fall into tunnel vision because of all of the tensions and the loaded or the freighted nature of your decision making. But how are your constituents going to be affected by your decisions? Lawyers are used to making decisions that relate to a client. But in this case, we had multiple constituencies. We had students and their families, faculty, staff. We had others. We had government officials, neighborhood residents, and all of those were going to be impacted by our decision making. Another thing that I think is fundamental to lawyering in a crisis situation is to identify the things that you can control, because not everything is within your control, but in the first order of decision making, those things that you can control and either make decisions that promote safety, mitigate risk, or prevent further harm are things that you can take advantage of. The last thing I'll say is, the last point I'll raise is accountability. We made a lot of decisions where, as I've said, either the legality or prudence were not proven. Lawyers are accustomed to being accountable to clients and courts, and we often service fiduciaries, but being accountable in a crisis puts added pressure on all of those elements of being an effective lawyer. Your judgment is tested, I think, sometimes on an hourly by hourly basis. Certainly during the pandemic, it seemed that way. And everything we did in a team approach, as a lawyer, you're weighing how far an organization can push boundaries, particularly in a crisis. And when the guidance isn't clear, you can't say, I don't know what a court will do. You can't say the law isn't clear. That's not advice and that isn't judgment. So we sometimes have to be accountable by offering judgment that is grounded in other components. Are we making good decisions for the benefit of the community as opposed to a singular dimension, for instance, cost? How will this be viewed? And in making that decision, are there other precedents or other analogous situations that you can point to, even if clarity on that specific decision isn't clear? And ultimately, as fiduciaries, are we making the best decision on behalf of the enterprise and its mission?
Ralph, thank you so much for that really excellent summary of considerations. And in a way, it leads exactly into what I want to talk to Bea about, because the crisis that, Bea, I'd love you to talk about was one in which not only was there whole complexity about who the constituents were and what the facts on the grounds were and how to understand the ramifications, but you were also dealing in a situation not just of legal uncertainty, but one in which maybe the right cause of course of action was one that would really push hard against existing legal frameworks, and yet maybe that's what you thought was necessary in order to try to address the unfolding humanitarian crisis. And so I wonder if you might say a few words about how you really struggled with and ultimately came to terms with that really difficult Gordian knot.
Sure, thank you, David. So this case study takes us back to Haiti in 2010. We were 9 months after a devastating earthquake that had killed about 200,000 people and displaced a third of Port-au-Prince's population. It had flattened 28 out of the 29 government buildings in the capital, including some of the major courts. And so at the time that cholera broke out, it goes without saying that Haiti was already in a state of crisis. And then in October of 2010, I was a young lawyer. I had just arrived in Haiti a month earlier after graduating from law school in the United States. And we started receiving reports that people were quite literally dropping dead from an unknown disease. In the first week, there were 1,000 cases, 135 deaths linked to this disease. And shortly thereafter, the Haitian government confirmed that this was the first cholera outbreak in Haiti's history. And cholera is a waterborne illness that kills through dehydration. And so it's not an emergency for people like us who have the privilege of being able to access clean water and sanitation. But it was for the majority of Haitians who live in extreme poverty throughout the country. And shortly after cholera broke out, evidence also began emerging that the source of the outbreak was a UN peacekeeping base. We found out that peacekeepers had arrived from Nepal, where cholera is endemic, a couple of weeks before the outbreak started. Journalists who went to the base, they uncovered leaking pipes and the dumping of fecal matter into open air pits that overflowed into a nearby village, as well as an adjacent stream. And that stream itself fed into Haiti's largest water source, the Artibonite River. And from there, cholera exploded across the entire country. In the first month, 2,000 people died from cholera, and we knew it was only a matter of time before it would reach the capital, where over 1 million people were still living in displacement camps. But this turned from a humanitarian crisis to an accountability crisis that called on the expertise of lawyers when the UN responded to all of this by denying the evidence and refusing to even investigate the source. And so we had activists come to us, ask us to try to use the law to seek accountability and justice for victims. This was an entirely novel situation. We were human rights lawyers working in Haitian courts in international fora, and we had experience responding to grave human rights abuses, even natural disasters. But suing the UN isn't something that's in most lawyers' repertoires, and it certainly was not in ours. And so against the situation, I want to highlight 3 kind of professional responsibility considerations that I think are also relevant to other contexts of crisis lawyering. And I think you'll see some similarities among these points and the points raised by Ralph. But the first is, who do you take direction from? And so as we talked about, the professional responsibility rules envision us having duties to our clients. But in many crisis situations where you're not working in-house within an organization, you may not yet have clients who are able to give direction as to how to respond. And so in that context, figuring out who the key constituents are is a key preliminary step in the work. And in human rights practice, we emphasize the importance of centering the most affected communities and people in those circumstances and taking a lead from their perspectives as to what needs to be done. But we also want to be mindful of taking direction from other local actors, including local lawyers, activists, existing movements, and be willing to work in support of them rather than centering our own perspectives as to what needs to be done. And in this particular situation, those actors were quite clear that they wanted to seek justice for what was happening in Haiti. Which brings me to the second point, which I think is, how do you act when the law isn't conducive to your client's goals and needs? And so in this context, the UN has immunity pursuant to treaty from, quote, all forms of legal process. It also has an obligation to settle claims by civilians, but there's no mechanism that's ever been established in practice that provides a legal forum where you can go and seek compensation. And so as lawyers, there was no place, no forum for us to be able to essentially wage this battle for justice. And so we knew that doing it anyway and trying to pursue justice in this context would have us go up against the letter of the law in many ways. And yet we also needed to engage in creative problem solving to figure out a way forward. And in doing that, the third point that I want to raise is also the importance of considering the broader impact of both action and inaction in these circumstances. So on the one hand, we were thinking deeply about the cost of inaction. We were in an environment where I was working for one of Haiti's leading public interest law firms. And there really was nobody else who was ready to take up the cause and bring it to the international stage. At the same time, we also thought deeply about the repercussions on human rights more broadly and what it would mean to sue the United Nations in this context, where as human rights lawyers, we depend on a strong and viable UN in order to promote human rights. And so these factors all played in informing our designing a campaign in a way that we hope would ultimately strengthen accountability in the long run rather than take down the UN. And just very briefly, what we decided to do was to ultimately pursue legal claims against the UN, but to do it in a way that also would engage with some of the various factors at play, including in a way that would attract media attention, allow for public engagement, and set the stage for a public advocacy campaign that over the course of 6 years eventually mounted adequate pressure, where the ultimate outcomes was that we lost in court and didn't manage to secure accountability that way, but simultaneously generated enough public pressure that 6 years down the line, on the eve of the case being finally dismissed, the UN in fact admitted responsibility for the outbreak and promised a $400 million remedial package. We're still fighting for implementation of that. That's a story for another day, but I think that maybe brings me to my last point, which is also the importance of staying power. I think crises often demand a quick response and yet don't lend themselves to quick resolution. And so being willing to engage with these questions over the long run, I think are important for all lawyers who are responding to crisis.
Thank you, Bia. And it's a fascinating story. And for those of you who are really interested in this area, I urge you to follow Bia and her work in this area, which has really been path-breaking. But that last point about staying power is a perfect lead into, Jake, where I'd like to go with you. Because, and actually several of the questions that are already coming in sort of are highlighting this, that, you know, we sort of think of crises when the word comes up, what we think of is something like the COVID crisis, or we think of something like the humanitarian crisis that Bia has talked about. But that's not really the only place or that crises happen, and that organizations face all kinds of different crises really every day. And that's particularly true in the business context where you and Kroll do your work. And so the first part is thinking about what crises means to your clients. And the second part, which has already been teed up beautifully, particularly by Ralph, is that these crises are not legal crises alone. They are really complex, interdisciplinary, cross-disciplinary crises that require all sorts of skills. And Kroll is really one of the leading organizations in the world that attempts to bring together all kinds of professionals, including many lawyers, to the kinds of crises that your clients face. And so I wonder, Jake, if you could talk a little bit about the context in which you see it and how you attempt to bring these various parts together, and what role do you hope lawyers play in this process?
Thank you, David. It's great to be here. And there's a lot to unpack in that question. That is, in fact, what we do. So maybe first, it's helpful to provide at least my perspective on what we even mean when we say the word crisis, and to talk about looking at the topic of crisis through the following sort of core lenses. The first is to put the word crisis in context. You know, the common reflex is that a crisis is generally unexpected, disconnected from our regular way of existing. It's unpredictable, it's fast, it's acute. Things can happen in seconds. You know, this is the here and now, kind of the micro view. Think of a wildfire, a hurricane, a terrorist attack, a ransomware attack where we happen to spend a lot of our time, plane crash, a death on a movie set. You know, I have the privilege of having a senior colleague at our firm who was a leader of the immediate response to the Boston Marathon bombing when he was at the Boston Police Department. In the micro moment, those few minutes, the words unexpected, acute, horrifying were critical in terms of decision-making and leadership. But when you move out to the macro, I think it's important that we do that. You can really apply the opposite words to make sense of crises. In fact, they are expected. They're patterned. In many cases, the buildup to a crisis and even the existence of a crisis can be slow-moving. You hear the term, you know, watching a slow-moving car crash. In many cases, and frankly, in my view, some aspects of the COVID crisis were, in fact, very slow-moving. In fact, sometimes crises develop over millennia. Climate change, energy policy, cultural complacency or intolerance, profit motives, evolution of the supply chain, technology advancement and vulnerability. You start to see patterns and archetypes that emerge around all of these types of crises. And I guess the key point that I would say is that data is key to understand the pattern recognition and the muscle memory that is often so critical in those micro moments. Crises are not unique events when looked at through these lenses. There are certainties. One thing I'm certain about is that we live in a VUCA world. And for those unfamiliar with the term, VUCA stands for volatility, uncertainty, complexity, and ambiguity. These are words that a number of my co-panelists have already used. And VUCA is a certainty. So my first sort of comment is think about crisis in context. And sometimes it's really important to come out to that macro view. There are patterns. The second point is that each crisis has a life cycle. The life cycle will vary depending on the nature of the crisis, but they often have similarities. They often have precursors. They often have the scramble after the event. There's the diagnosis and the investigation, which is where we do a lot of our work. There's the remediation. In many cases, there's the retribution. And of course, there's the ongoing learning and the prevention. Understanding if the crisis has which of these elements and where you are in this life cycle is really, really critical. A lot of the work that we do has to do with assessing where we are in the life cycle of an event. A crisis is an event, but there are definitely precursors and postcursors, if that's a word, and understanding where we are is really key. We were called in by a lawyer, and I'll talk about the role of lawyers in a moment, in the aftermath of a major cyber breach. And understanding where we were, the event had already happened, but we came in the moment where there was the scramble. The scramble then had to lead out to all of these different tentacles around what do we have to diagnose? What do we have to investigate? Where can we start remediating? And making sure that we were sequencing and understanding where we are in that sequence was really critical so that we didn't get ahead of our skis, but at the same time, we weren't behind the curve. So knowing where you are in the crisis life cycle is key. Finally, and this point has been made by a number of my colleagues on the panel, crisis is an ecosystem. David, this was the term that I used with you when we spoke earlier. There are so many constituents that have to be analyzed. And in our view, we view every one of these in some way, shape, or form as our client. There's the subjects of the crisis itself, counterparties, lawyers, insiders, boards, insurers, communications directors, supply chain participants, accountants, customers, the press. Nothing happens in a vacuum. If there's a fire, it's not just about calling the fire department. Knowing who the actors are in the ecosystem, what roles and responsibilities are, where those roles are okay to stretch. I think someone said that lawyers can't just be lawyers, and I believe that's true, but we have to understand what the limits of expertise are. who you can trust, what agendas exist. And one thing I will say is there are always agendas. They might be good agendas, but agendas exist. Knowing these attributes can really make all the difference. So think about context, life cycle, and the ecosystem. That's really, really key. A few paradigms that members of our team use when we go in, for example, to investigate a cyber breach or a whistleblower complaint, or a theft of intellectual property, or a theft of actual property. These are pretty straightforward paradigms that we tend to use when analyzing the situation. First, gather information and gather the right information. As I said earlier, data is really important, but there is a lot of exogenous data that really does not matter for you to tackle the mission in the here and now. The here and now is really important. So the second point is stay focused. Stay focused on the immediate objective. Mission creep can really take you backwards if you lose that element of focus. The third is do no harm. And a lot of crisis management, I believe, is borrowed from the medical profession. So do no harm. You are coming into a situation that is traumatic, and the most important set of objectives and goals is to make sure that you're not making the crisis worse. I think it was Bea who said there's a choice often of action or inaction, and understanding which of those paths to take really is critical in doing no harm and trying to advance the objective of resolution, if not prosperity. Finally, and this really comes into play when we come into a situation and when lawyers come into a situation, is remember your outsider perspective, okay? There's a subject of a crisis. It might be a company, often is the case in our case. It might be a government, might be a country, might be a society. But when we are called in, we have to remember our outsider perspective and do our best to actually, while understanding other people's agendas, not be compromised by our own agendas. We are not insiders. We have to offer objective advice. So when it comes to how we interact with lawyers, David, just to wrap up my comments here, in my experience, lawyers are often the first call in a moment of crisis from the affected party. I don't know the statistics on this, but I would suggest the vast majority of situations are that lawyers are the first call. The general counsel may be inside initially, and then that GC or some other risk manager is calling a lawyer. And they're calling the lawyer not just because they want legal advice. In fact, that might not even be the reason, but because lawyers have the privilege and the accountability and the responsibility of being that most trusted advisor in a time of crisis. But then very quickly, the lawyer takes on a very different role. And in our world, the lawyers are often serving as the general contractor of managing a crisis. The lawyers are often, in fact, hiring us and hiring many other advisors or triaging the decision-making about who to bring on, often in a moment's notice. So the lawyer is really a key gatekeeper and an extension of the client or the affected party's interests, and is effectively, in our world, serving as the client. It's very common for us to really only only interact with the lawyer who is giving us direction or is taking advice from us, and then triaging that back to the rest of the ecosystem that I just talked about. So our relationship with lawyers is often on the receiving end of a call from a lawyer. And what I would suggest to any lawyer who finds himself in a moment of crisis and representing a subject as an advisor, that having that ecosystem of other subcontractors, if you will, and advisors at the ready, knowing who to call quickly, that you trust for their expertise and their outsider perspective is really, really key. So,
Thanks.
David, those are my perspectives.
Thank you, Jake. That's incredibly helpful, as I knew it would be. And again, we didn't practice this, but you've now teed me up exactly for where I want to go with Tom, because I don't think there's anybody in a position where the clients are not just multiple, but everyone, like the people of the United States of America, at least on one brush, where you have to occupy both the insider and the outsider perspective as a senior government official who's both representing the interests of the people of the United States, but also overseeing things that are deeply important to individuals, communities, businesses, et cetera. And where everyone expects you to be the general contractor role, but where your authority to do so is oftentimes constrained. And so, Tom, I think you heard Eric say that he started this project by trying to help to think how to help government do better. You're now in charge of trying to help government do better, and you've seen it both from a senior principal role, your current role, but also as a leading lawyer in government as well. And so I wonder, you've now listened to these various perspectives, if you could give us your own on thinking about how you think about crisis lawyering or crisis management and the role of lawyers in that process.
Well, thank you. And thank you for mentioning that I'm a government employee, because I wouldn't be a good government employee or attorney if I didn't give the disclaimer up front that none of my views today or anything except my own, they don't represent that of the Department of the Interior or of the United States government. That being said, anybody who knows me knows that most of my opinions are my own and I don't hold them back very much. My bias is to government and emergency response. All right, as was mentioned, I was a volunteer firefighter. I'm kind of semi-retired from that these days. I worked in private practice for a while, but just before 9/11, I started with the state of New Jersey as an emergency management and then eventually a Homeland Security attorney. Went to FEMA for a while, and now I'm at the Department of the Interior, where I'm the director of emergency management. I'm not in a legal role, but I get to deal with our fantastic solicitor's office, who I'm trying to introduce the concepts of crisis lawyering to, and I'm also kind of a preacher of conversations between lawyers and clients. Because one of the worst things I find, especially in government, I don't know how it is in the different sectors that the other panelists work in, is the clients also often come and they ask a yes or no question. And that's probably the worst thing you can do to an attorney, because if you ask a yes or no question, you get a yes or no answer. And my experience in government, that answer is more often no than it is yes. And that creates a lot of problems. So at Interior, it's a fantastic practice I have in emergency management. We've got lands throughout the United States. We've got interests everywhere. You name the hazard, we're involved in it in one way, shape, or form. Of course, lately, COVID's been my chief emergency. That's what I have to deal with. We get a month to turn around putting together a system to collect all of the vaccination information of all of our 60,000 employees. And I have to turn to my solicitor's office, and they're fantastic. And I have to say, here's what we need. And I need you to help me work through this, because I don't know what I don't know, right? I'm turning to the attorneys to say, hey, I don't know what it takes to get this up and running, but we have 30 days and it has to be complete and we need to be going. So getting a good response, getting a good conversation going, not saying, hey, can I do X? And then getting a no answer and coming back and say, hey, can I do Y? And getting a no answer. It's a dialogue, it's a conversation. Start with, hey, here's what I want to do. Help me get there. Tell me where I need to change, what I need to do to get there. But it's also been interesting because COVID, I think, has expanded crisis lawyering from just the what I would call the traditional emergency management type attorneys to a whole host of others. I mentioned the employment law attorneys, right? They're key in all of this. As you're dealing with COVID and as you're dealing with employees and whether they should be vaccinated, whether they should be wearing masks, whatever it is, there's a lot of stuff that comes into play. But it's also stuff that suddenly you need an answer to. Now, I can't wait 6 weeks for a memo. I need an answer today. I need an answer tomorrow. And speed is something that you often see in crisis lawyering, is always a challenge there. So you see this suddenly spreading out. Contracting lawyers. I need N95 masks. I need 100,000 of them. I need them tomorrow. And I don't have time to wait for a 15-week contracting process. How do I get this done? Right? Talk to the contracting attorneys, find the exceptions, the ways to get that done in government. I find, for me, the simplest role of an attorney is to help the client accomplish the goal or accomplish the outcomes they need to achieve. And limit their exposure to, as I put it, going to jail or getting fired, right? It's a client, I don't want to go to jail, I don't want to get fired, but I do want to know what my risk is. And, you know, so that's it. And within that area, I think there's a couple key concepts that I've seen over the years. I think a crisis attorney really needs to have a solid understanding of the law that they're dealing with. And it's not always going to be the same area of law, but you don't need to be the expert. You don't need to be the definitive go-to person on fill in the blank law. You just need to have a good enough understanding that you can make a call on the spot that you feel is going to enable the client to get what they want done. 9/11 with New Jersey, I've been there about 3 months, and suddenly I find myself in the spotlight because Mayor Giuliani gets on the TV and he says, close all the bridges and tunnels, keep everybody out of New York. The captain of state police, who was the incident commander at the time, turns to me and says, can we do that? I had enough knowledge to know that the state of New Jersey emergency power said yes. The governor empowers the state director of emergency management to control traffic throughout the state during an emergency. And the governor was upstairs and said, as soon as you get the order done, I'm declaring that emergency. I had enough information right there that I said, yes, do it. Be done with it, right? Off they went, they did that. I think you need to be able to communicate the legal risk to clients in a way they can understand it. I kind of jokingly used to tell my team of attorneys at FEMA, remember when you're writing for senior executives, and I guess I'm insulting myself as a senior executive now, they're kind of simple, right? They're not into 27-page legal memorandums. You get 3 paragraphs, restate the issue, add in any additional information, give them a short answer, and then just a short explanation. Then look, attorneys have an obligation to make sure that you fully set forth the law, that you've fully given all the options and everything else. Take that 27 pages and fill in the blanks, but they're not reading beyond that first page. Know that. So communicate what you need to communicate in that short form. Same goes for when you're talking to a client. You need to be able to communicate to them in non-legal terms, because the average client isn't going to understand the legal concepts you're putting in front of them. The information they need to have to understand the risk they face in making their decision. There was a situation where kind of crazy grant situation, but Congress put language in a bill that said you can only fund up to 85% of the risk on this particular grant. Crazy language, right? A lot of interpretation behind it. Don't need to get into the details of it. But it came down to one day when there was, if we did 85.5664, whatever the decimal was, a little more than 85.5% of the risk, we could get 2 more jurisdictions funded, where if we didn't do that, an influential congressman's district wasn't going to get funded. The client wanted to take that and say, oh, we're rounding down. There was no conceivable way that, but it's not a legal issue, right? The language is there, it says 85%. Rounding, that's not a legal issue. There's no law that says you can't round in government. But we were able to explain, it wasn't even me, it was one of the attorneys working for me, explain to the client, hey, you're going to get a very violent reaction from Congress. They put this language in there for a reason. They don't want you doing it. Now, I understand that you also have the risk that you're going to make a very influential congressperson very angry because their jurisdiction's not getting funded. Ultimately, the client appealed it up to me, didn't like my attorney's opinion, and I basically backed my attorney and said, yes, that's absolutely right, but it's your call. You can do what you want. You're not going to go to jail. You're not going to get fired. So this is the risk. We've explained it to you. Now make your decision. Well, they decided to take our advice, didn't do this little rounding thing. When they went to the Hill to explain what was going on, they got asked about it and they said, well, we could have rounded down, and they said, no, you made the right decision. So nice vindication there to have somebody else say it, but just be able to communicate that risk, tell them when it's something that they really need to avoid, and then go from there. And you need to also have conversations with clients. This is a yes or no question I asked before. One of the reasons I really got interested in crisis lawyering was I read an article in one of the New Orleans newspapers back in 2008, 2009, that the headline was Failure of Katrina Housing Program, Fault of the Office of General Counsel. And I sat there, and I was in New Jersey at the time, said, how could the general counsel's office be responsible for the failure of the entire Katrina housing program? And it talked, in general terms in the article, but it referenced a GAO or an IG report. And I went and read that. And I read that report, and then I made some calls to attorneys I knew at FEMA. And literally what happened was somebody in the command center came to the attorney and said, I want to do X. Is that okay? Can we do this? And the attorney looked at him and said, no, you can't do that. And he said, okay. And they turned around and walked away, went back, said, oh, we can't do that. There's nothing we can do. Have a nice day. So that yes or no question created an entire situation in which the perception was that a failed housing program was the fault of a lawyer. If they said, well, I don't think you can do what you're asking for, but what are you trying to accomplish? And had a conversation. Maybe there's a completely different result that happens in the end. So don't take those yes or no questions. Don't answer them as yes or no. Have a conversation. I try to teach my fellow SES at Interior, don't ask yes or no questions to the attorneys, talk to them. If you got to say no, you're not there to say yes, right? That's not the job of an attorney. But if you have to say no, say it in a way that I can understand why you're telling me no. Give me some information that goes with it. Let me understand it. Let me know why, so that I can justify it up my chain of command, that I can do things like that. I heard a couple of the panelists already talk about being a partner, or being, what they say, don't just be the lawyer, be a trusted advisor. Clients are going to turn to the lawyer. Yeah, absolutely, be a partner. The more of a partner that you are, the more likely it is you're going to be at the table to start with. And you have the opportunity to be part of the solution rather than be called up. And I'm not sure who said it on the panel already, but do you want to be called in to mop up afterwards, or do you want to be there so that the solution's there and you don't have to do the mop up in the end? And the last piece I think that's important to crisis leadership or crisis lawyering is leadership. And I don't think we do a good job with attorneys of teaching leadership. And it's an interesting science, and there's a whole some of my classmates in a training program I did a couple years ago used to jokingly call it the leadership industrial complex. There's a lot of stuff on leadership out there, but a lot of it's really good. And you as an attorney have the opportunity to be a leader. It's not going to be in your title. It's not going to be in your job description. It's not going to be in what you do. But you have the opportunity to sit there as a partner at the table and help lead the direction of an organization using your legal skills, but knowing some leadership concepts that'll help you move the goal to where you need it to be, so that there's a favorable outcome for what your client wants to achieve, but also that helps you manage that risk that you're always going to be concerned about, and helps you be a partner at that table. So I think there's a lot of things we can do there. And it's just an opportunity. I think as a client, I want an attorney that's going to talk to me, that's going to explain to me, is going to engage with me. I think as an attorney, I've always wanted to be that kind of, provide that kind of service to the client. And I think, and I noticed one of the questions in the Q&A earlier was along the lines of, and I'm really butchering it, but it was, how do we teach this? How do we engage this? Is this something we got to teach in law school? Is this something you learn on the job? What is the way of doing that? And I think that's a great question. I think it's something we need to look at.
So Tom, that's a perfect segue to tell everyone who's on right now to stay tuned to the next panel, because that really is the focus of the next panel, and it's being led by my terrific colleague Scott Westfall, who runs our executive education programs and has also done a lot, even with our law students, around leadership training. So thank you very much for that. I want to come back, and this is another set of questions in the comments, Ralph, to you, because a lot of what's been said has to do with, you really need to look at the wider picture, you need to consult with people, you need to think about all the various interests, and I can only imagine in a university setting where there are students and faculty in the community, where Northeastern is situated, and the board of trustees, and all sorts of alumni. I mean, there's all these constituents, but of course they all want maybe different things and have different perspectives. and they're not unified. There's no such thing as the student perspective or the faculty perspective. And yet time is often of the essence. So I wonder, how do you, or how did you go about trying to understand these various points of view? And then how do you balance them to try to make the kinds of recommendations that I think Tom and Jake were talking about?
So I would say the good news is we've used those muscles before, because it is such a dynamic and complex organization, and it's only gotten more so over the past 10 plus years that I've been here. So we have an active student body, we have an active alumni body. We reside in the middle of 4 neighborhoods, and we're neighbors to all of those neighborhoods. And so that just mentioned some of the constituencies. So it's an ongoing thing to try and hear and resolve and calibrate. I would say, I was reminded of a very famous quote by one of our lawyers who, every week we have a team meeting and everyone's invited to submit a quote, and he submitted a quote from Mike Tyson of all people, which is, everyone has a strategy until they're punched in the mouth. And so using the pandemic as that, to fit within that metaphor, there's nothing like a crisis to focus the mind. And at a certain point, while you can't be oblivious to all of the incoming, you've got to be focused on what's the touchstone for what we are trying to do here in the middle of this crisis. And the touchstone for us was safety. And so everything became rationalized, absorbed and synthesized, and then decisions made based on safety, because that was the one thing we felt would support and buttress the legitimacy of anything we decided going forward. So maybe the most fundamental thing is, in the midst of a crisis, what is it that you're seeking to achieve? What are the 1, 2, maybe 3 things that you're seeking to achieve, and rationalize everything towards those objectives rather than the noise.
So Jake, I want to kind of pick up from that and pick up on something you said earlier, and maybe related to something Tom said, which is you're oftentimes brought in by lawyers, right? Because they're the first port of call, so to speak, when a crisis happens. But as Tom said, lawyers are not necessarily trained to respond to crises in a way that understands their full complexity. They could also, just to be a little blunt, be a little territorial, and I think, as others have said, be a lot risk averse. And so I wonder how you navigate that with lawyers. And this is actually both the lawyers that are bringing you in, but also the lawyers on your own team, because I know you have a number of lawyers on your own team, to get them to understand this kind of broader perspective that ultimately, even in a business context, is in that long-term interest of the business. In other words, it's not just to get the immediate answer to solve today's problem, but they have to think about what the long-term implications are for their business, for their relationship with regulators, consumers, employees, all the rest. How do you do that?
There's no straightforward answer to that. In almost every case, facts, circumstances, and personalities will dictate how we and any member of that ecosystem that I talk about will engage with each other. But I would suggest that what Ralph actually just alluded to, finding that in the here and now moment of crisis, finding that that distinct objective, or that touchstone, and it's a great word, that you can have everyone rallying around, I think is key. Otherwise, you end up with mission creep, as I said, and people pursuing multiple agendas. And when people are pursuing multiple agendas, that's when crises become exacerbated and you actually do the harm and do more harm versus actually solving the problem. So it really comes down to making sure there's a clarity of mission when you are called in by a lawyer, or when we're calling a lawyer in. And if there is a disconnect relating to what that touchstone is, then you need to go into what I would call immediate mediation and resolution mode. And there are numbers of ways to achieve that, either through like here and now facilitation, or ultimately either if you have to figure out what your leverage points are. If there's a disagreement with effectively your client or your lawyer, I think Tom was talking about the idea, if you're forced into a corner, into a yes or no situation, you have to assess what leverage do you have to actually change the dialogue to a conversation, to a resolution, or, I hate to say this, either displace or resign. And you have to figure out what those pressure points are that you can utilize. Hopefully, you're working with the team that can center around that touchstone. But if not, you have to go into resolution mode.
So, Bea, no one is pressed in some ways into resolution of conflicting interests more than a human rights lawyer. That's one of the things we discussed when you came to my class. And I wonder how you think about the kind of connection between the normal lawyering tools. So your example is you sued the UN, that's a normal lawyering tool. But ultimately what you were interested in was a kind of negotiation, universal settlement, taking up responsibility that made your clients feel valued, but also brought them some immediate benefits that, quite frankly, litigation might take years and years to do. And I wonder how, as a human rights lawyer in these sorts of crises, you try to balance those things.
Yeah, thank you. I mean, I think oftentimes in responding to crises, as we've discussed, the law doesn't lend itself to neat solutions, or the problems that we face don't fall into those boxes. And so in that sense, I think in crisis lawyering, we often have to be jack of all trades. And I think that there is an important balance to be struck between leading, as Tom mentioned, but also leading with humility. And I think understanding where we can bring expertise, but also how we can bring in others, and where other people's expertise can help widen our perspective on issues like this. In the context of cholera, that was critically important, because I think ultimately the thing that was the most valuable was using legal tools, but also understanding the context in which they were playing out, how they were perceived, and very strategically engaging other allies from across professions, but also parts of society, really, to try to bring them on as allies. And I think in that context, we were able to play a leadership role by keeping an eye on all of those moving pieces, but also trying to grapple with how we do that in a manner that can place other people at the fore, and ensure that the conversation also doesn't get dominated by legal considerations. And I think that's one of the words of caution that I would leave everyone with is to make sure that we keep that broader perspective in mind as we lawyer through these situations.
That's just absolutely critical. And Tom, you've already alluded to this. I'm going to bring Ray on now just to give a concluding remark, but Tom is a lead-in into this. Because in some ways, because this project started out thinking about government, and government inherently has to balance three domains: the legal domain, the policy domain, and the political domain. And you are sitting right in the midst of it. And I wonder, as Ray comes back on, how you think about a government lawyer thinking through those three aspects of policy.
That's a tough one, because it's probably part of the hardest part of the government attorney's job, is how to deal with you know, there are other influences there. The political influence is probably one of the biggest ones, but, you know, in policy, we just went through an administration change. There were policies that went from one side of the world to the other side of the world in certain areas. Flexibility and, you know, there's a lot to balance there. And I guess it'll go back to leadership training or learning how to deal with conflict, because you may not agree with policy, you may not agree with the politics, you may not agree with what's coming down your way, but you have to react to it. And I think the comment before was, I forget exactly what it was, something or resign. Sometimes it's something you have to face, but you have an opportunity to help educate, shape, learn. And if you become that trusted partner, if you've become that person who can walk in and have the conversation, you have the opportunity to help balance off of those points, but it can be very difficult. You know, we live in very contentious times. We live in, you know, people are angry about whatever the policy is. And I don't care which party's in control of the White House. I don't care which party's putting something up. There's somebody that's not happy with it. And as a government employee or as a government attorney, that's a lot to balance. That's a lot to deal with, because, you know, you've got employees on both sides, you've got administrators on both sides, and you have to learn how to balance that. And that's a tough skill. It's not something that comes easily, but it is something that I think any good attorney, and particularly a crisis attorney, is going to need to learn, so that you can balance that, so that you can work with the whoever it is to help balance the policy and the politics and everything else that's involved in it.
So Ray, I know you understand how difficult that is, and what Tom just talked about, as well as the other remarks. We're right at time on the panel, and we really do try to stay on time. But if you have a brief concluding remark before I thank all of our amazing panelists.
Yeah, very quickly, thank you, David, and thank you all the panelists. I really like the metaphor of the ecosystem that Jacob used, and then I heard a theme throughout, which was accountability, and that accountability in the crisis ecosystem is very different than the normal accountability we might hold to the lawyers, between lawyers and clients. I think it sort of can be summed up in what Louis Brandeis referred to in his own role as a lawyer, that he often saw himself as the lawyer for the situation and not necessarily for a particular client or constituent. Now, that may make us feel uncomfortable. We obviously have to have loyalty to our clients, but I think what I was hearing throughout all of this, and what you'll see throughout the book, is that that accountability in crisis situations is broader, is more complex, is more diverse than in the typical situation. But I'll leave it there. And I think there's a lot more that everyone's going to talk about on these points.
Well, Ray, I can't imagine a better way to close a panel than with Brandeis, particularly with these Brandesian figures that we have had here with us today. I just want to thank Tom and Ralph and Jake and Bea so much for giving us their time and their wisdom. I know that our audience enjoyed it as much as we did participating, and I hope that all of you will come back. We're going to just take a quick 15-minute break. We'll be back right at 11:45 Eastern time. Not sure what time that is for you, to really take up Tom's challenge of how do we teach these skills and what should we be teaching. But for now, please help me give a virtual round of applause for our amazing panelists. Thank you very much. Thank you.
Thank you.